Look, you should always be thinking about it, whatever age. I find that there are certain life events that trigger people to think about making a will, and one of them is starting a family. I had some beautiful clients in the other day who just had a first baby, and that prompted them to think about their will and how they would want to leave their estate if something happened to the two of them and how they'd provide for their child. So that's usually a trigger for when people think about looking after their family. Certainly towards the end of life, people often thinking about wills. But look, any time is a good time to make a will. The sooner the better. It's never too early to make one, but it can be too late to make one. You need to organise yourself, and as much as you put it off and put it off and put it off, it's something that you really need to do sooner than later. There's no avoiding it. No one's going to avoid death, unfortunately. It's something I've learnt over the years, that as much as you think this won't happen to me, I can assure you death is something that's going to happen to all of us, and the sooner we deal with it like, adults, the better for everybody, yeah. So the will deals with your assets after your death. That doesn't come into effect until you die. So a lot of people have a confusion about when the will operates. It doesn't come into effect until after you've died. The power of attorney deals with your legal and financial matters and who can make decisions for you if you can't make decisions while you're alive. So one deals with your circumstances while you're alive, and the other one deals with after you've died. The enduring guardian deals with medical and lifestyle decisions, so if you can't make a decision for yourself, you've appointed someone else to make those decisions for you. Well, if you die without a will, you're creating a lot of extra work for your family that you may not, you certainly won't want to be doing that for them. If you die without a will, then they need to sort through your assets and make applications to the court, usually, depending on what assets you own, and somebody will have to nominate to be your administrator of your estate rather than the executor, which is what you do in a will. And that means that extra time, extra effort, extra searches, money has to be spent to administer your estate, and that can be avoided if you do make a will. So it's impossible to make a challenge-proof will. It just can't be done, because there are certain people who are entitled to make a claim on your estate as eligible persons, and you need to be aware that if they haven't been adequately provided for, they may have grounds to make a claim against your estate. So if you are deciding not to include someone in your will that could be an eligible person or is an eligible person, you need to think about expressing the reasons why you've done that and put that in a document separate to your will, so that that can be referred to in the future if necessary. The thing I've learnt is that you can't judge anybody. Everybody comes to you and tells you their story, and I've learnt not to judge anybody, and everybody is unique. They've come to where they are in their life by various roads that they've taken, and I think that's an important thing that I've discovered over many years of practice.